Welcome to the City of Oakland's Public Ethics Commission virtual training on administrative hearings. The trainings will cover the following topics. Let's walk through them. What is a PEC administrative hearing? How an administrative hearing is initiated, duties and roles of the parties, procedural due process, preliminary matters, issuing subpoenas, hearing procedures, making findings of facts and conclusions, imposing penalties, issuing a final order, and court review. What is an administrative hearing? An administrative hearing means a hearing before a hearings officer where laws, rules, ordinances, and factual evidence are presented, considered, and a decision is rendered. Administrative law hearings, like the Public Ethics Commission administrative hearings, are less formal than courtroom trials. For instance, although the PEC formal hearings are open to the public like courtroom trials, the different feature is even the administrative process is open to public comment. Witnesses are excluded as needed, but the goal of a PEC formal hearing is to provide a neutral and impartial forum in which the parties may resolve an issue in dispute. The hearing officer is to conduct hearings in a fair, effective, and efficient manner. The hearing officer renders sound and equitable decisions in a timely fashion based on all the factual evidence and testimony presented. What are the stages of a Public Ethics Commission's administrative hearing? The process is initiated by the enforcement chief, who makes a formal request for an administrative hearing and the probable cause memorandum to the Commission. If the Commission agrees to set the matter for an administrative hearing, the Commission also decides what format that hearing will take. Will it be conducted by an administrative law judge, an ALJ, or will it be comprised of a hearing officer from a subset of the Commission as a whole, or one commissioner serving as the hearing officer? Once that decision is made, notice is given to the parties regarding the hearing being set. After the hearing is decided, preliminary matters are scheduled. The date of the trial, the hearing, issuing subpoenas, considering motions, all matters that have to be decided before the hearing is conducted. Once those matters are decided, the hearing is conducted. The hearing officer, after presiding over the procession, prepares the final findings of fact and recommendations. The final findings of fact and recommendations are forwarded to the Commission, at which time the Commission makes the final determination and decides the penalties. What are the roles of the parties involved in the administrative hearing? The hearing officer conducts the hearing, decides preliminary matters, is the decision maker for the process, and makes findings of fact and conclusions. The enforcement chief makes a request to the Commission to find probable cause and schedules a hearing. The enforcement chief also recommends penalties. The executive director facilitates the process and the communications between the parties. The executive director also initiates the notice of the hearings and coordinates with the administrative law judge. The Commission imposes the final order and penalty. They find probable cause and decide to hold the hearings. The Commission also makes final determinations and imposes penalties based on findings of fact. The Commission assistants are the calendar clerk for the hearing, receives documents, tracks deadlines, and schedules the dates. The city attorney provides advice and support to the hearing officer, explains the rules and procedures to the hearing officer.
We will now discuss the process of initiating an administrative hearing. The process to schedule an administrative hearing starts with the PEC's enforcement chief. Usually, the enforcement chief will decide to request a hearing if they have determined after an investigation that a respondent violated the law, but they have been unable to reach a settlement agreement with them, either because the respondent is disputing the evidence and/or the respondent disagrees with the suggested penalty. The enforcement chief might also request a hearing if the respondent has refused to negotiate or hasn't been responding to staff at all. In all these cases, the settlement process has reached an impasse, and there is a need for a neutral hearing officer to help resolve the case. The actual procedure to request a hearing starts when the enforcement chief submits a written recommendation to the full commission at one of its public meetings as an action item. This document is usually referred to as either a hearing request or a probable cause report. Those terms mean the same thing. In the report, the enforcement chief summarizes the evidence gathered in the investigation and argues that there is probable cause to believe that one or more violations of the law occurred. The report also recommends that a hearing be scheduled on the matter. It is then up to the full commission to vote on two things: whether there is probable cause to believe the violations occurred, and whether to accept the recommendation to conduct a hearing. At this time, the Commission must also determine who will conduct the hearing. They have four options. The first option is to have the full Commission sit as a hearing panel, with every Commissioner acting as a hearing officer. The Commission chair or their designee would serve as the hearing chair. The second option is to only have one or more commissioners delegated to sit as a hearing panel instead of the full commission. In that case, a member of the panel would serve as the hearing chair. The third option is to have an independent hearing officer selected. In other words, somebody who is not currently sitting on the commission. The executive director would select the independent hearing officer from a list. The fourth option is to petition for a California administrative law judge, or what's called an ALJ, to conduct the hearing over at the State Office of Administrative Hearings. There is a monetary cost associated with this option, which can be $10,000 or more.
Hearing notice. The executive director must give notice of the date, time, and location at least 30 days prior to the hearing date. Also, notice must be publicly posted online and with the city clerk 7 days prior to the hearing date.
We will now discuss the role that due process plays in administrative hearings, as well as your due process responsibilities as hearing officers. Due process is comprised of two main parts: notice and the opportunity to be heard. Notice must be given to the respondent, which means that they must be given notice of the date and the time of the hearing, what the respondent is accused of, what evidence will be used by the government, and they also are afforded an opportunity to be heard, which means the right to defend oneself and the right to present evidence or to request a continuance if surprised with new evidence or claims. Under the umbrella of the respondent's opportunity to be heard is the important sub-issue of their being entitled to present their case to a fair and neutral adjudicator or body. The fair and neutral adjudicator requirement could be considered a third component of due process. At its core, it means that all parties are entitled to appear before a neutral or a body that is free from actual bias and financial ties to the matter being heard. We say actual bias because there is a rebuttable presumption that all neutrals or bodies are unbiased and free from financial conflicts from the start. This presumption can be overcome, however, with evidence of actual bias or of a financial conflict. Examples of actual bias include having a financial stake in the outcome of the matter being heard, or personal connections or relationships with one or more of the parties. Finally, as neutral hearing officers, you should refrain from discussing the matter with anyone prior to the hearing. We will now discuss procedural and process matters that may precede the actual hearing. These are known as preliminary matters, and they can be found in subsection 7D on page 11 of the complaint procedures, which is hyperlinked to this PowerPoint at the end of this presentation. Stepping back to look at the larger picture, preliminary matters include everything that occurs after the executive director sends out the formal hearing notice and before the actual hearing takes place. Under subsection 7D, any party may submit a preliminary matter for the hearing officer's determination. This submission must be in writing and submitted to the calendar clerk 7 days before the hearing. The party submitting a preliminary matter must show that they attempted to resolve it with the opposing party. Also, they must show that copies of the submission were given to the opposing party. You, as the hearing officer, can determine preliminary matters after both parties have submitted writings without an oral hearing. Examples of preliminary matters that you may ask to decide on are whether any claims, issues, or complaints should be joined together or scheduled separately, the scheduling of any witnesses out of order, discussing the production or exchange of documentary or testamentary evidence, the scheduling of a pre-hearing conference to discuss logistical or procedural matters, addressing issues of bias against you as the hearing officer, and any other matters that may arise that do not relate to the substance of the matter being heard before you. What we mean by do not relate to the matter being heard before you is not related to the truth or the falsity of the factual allegations in the accusation.
Time frames. 7 days before the hearing, preliminary matters may be submitted in writing to the Commission calendar clerk for a determination by the hearing officer. 5 days before the hearing, any written materials, non-subpoena, must be submitted.
The parties to a hearing can subpoena witnesses to testify or to bring documents to the hearing. In order to do this, the party must give the subpoena to Commission staff no later than 14 days before the hearing date. If the subpoena is for a witness, it must include the name and address of the witness, as well as explain why their testimony would be important. If the subpoena is for documents, it must provide a description of the documents sought, an explanation of why the documents are necessary for the hearing, and the name and address of any witness in control of the documents. Subpoenas may be issued by the PEC Executive Director before the hearing, or by the hearing officer if a request for subpoena is made during the hearing itself. In all cases, a subpoena can only be issued upon a showing of good cause, as described earlier. If the subpoena is issued, then the party requesting the subpoena is responsible for actually serving it on the appropriate persons, and must provide a copy to all opposing parties. A request to postpone a hearing may be granted prior to the hearing only upon written request to the Commission Chair or hearing officer. During the hearing, a matter may be postponed or continued only for good cause shown, and upon approval of the hearing officer.
The hearing officer will provide an introduction and brief explanation of the hearing procedure to the parties. The hearing officer will also read a script provided by staff. Proceedings shall be recorded on audio and/or videotape and made available upon request. A party electing to have a stenographer present to record the proceedings may do so upon providing at least 3 full business days' notice to Commission staff and at that party's own expense.
Now that we've had the opportunity to discuss the hearing procedures, what is the hearing format of an administrative hearing? Very similar to a civil or criminal trial, the unique difference of an administrative hearing is the right for public comment. No rules of evidence apply, and neither party is afforded the opportunity to cross-examine each other's witnesses. Like a trial, the process begins with opening remarks. Opening remarks, or the case summary, starts with the complainant because the complainant has the obligation to prove the case. The hearing officer is responsible for setting the amount of time allowed for the opening remarks. 10 minutes, 20 minutes, 30 minutes. The appropriate time will be based on the complexity of the case or the volume of the evidence. Although each party is allowed to give an opening remark, each party has the right to waive an opening remark. The first presentation of evidence is put on by the complainant. The respondent has an opportunity to rebut the evidence put on by the complainant. Evidence can take the form of written documents, recordings, maps, pictures. The important thing to remember for the hearing officer is that formal rules of evidence do not apply. So there are no hearsay rules, no need to authenticate documents, and in fact, no need to put on witnesses. A case can be proved by the presentation of documents, recordings, maps, or photos. After the complainant presents its evidence and the respondent gets an opportunity to rebut evidence, the complainant is allowed to put on a presentation of witnesses. The witnesses present evidence by testimony. Before a witness is allowed to give testimony, the hearing officer is required to administer the oath or affirmations. The oath and affirmation will be provided in written form to the hearing officer. The hearing officer will be responsible for asking, "Do you swear under penalty of perjury that you will tell the truth during this administrative hearing?" It's important as a hearing officer to remember there is no right to cross-examination, but both parties will be allowed to rebut evidence or, through the hearing officer, ask questions of any witness to clarify or gain more information on a statement. After the presentation of witness testimony, the respondent is allowed to rebut by using witness testimony. Then the respondent is allowed time to present their witnesses and their case. The complainant, if the respondent puts on a separate case, has an opportunity to rebut that evidence with witness testimony and/or documents. After the completion of presentation of evidence, time is allowed for public comment. After public comment, the complainant and respondent are allowed time, just as in the beginning, to give closing remarks. It is the hearing officer that determines how long the closing remarks will be. Either party can exercise the right to waive a closing argument. Once the respondent presents closing remarks, the complainant is allowed one last opportunity to give a rebuttal remark. Again, complainant is allowed that rebuttal time because they have the burden of proof. Once the complainant has completed rebuttal, the hearing is closed. Throughout this training, you've probably heard some unique words and concepts. Ex parte contacts is another unique concept that applies in administrative hearings. Ex parte communications are communications with the hearing officer by a party without the knowledge of or outside the presence of the other party. No party or person shall communicate about the merits of the case with the hearings officer designated to hear and decide the matter other than at the time of the pre-hearing or the hearing. It is important for the hearing officer to also remind the parties to remain within the scope. Remaining within the scope of the hearing is sticking to the primary issues of what violations are before the hearing officer at the time of the hearing. Through this practice of keeping the parties within the scope, it helps the party to be more effectively focused on the proceeding and the issues that are before the hearing officer. Factual evidence is used to sustain or support a party's position, whether it be the complainants, the respondents, the appellants, or the appellee. Evidence is usually presented at the formal hearing and typically of two types: documentary evidence, which consists of something concrete, such as documents, records, and other similar materials, or testimonial evidence, is statements made under oath by individuals testifying at the hearing. Any relevant evidence is admissible if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs. Decisions made by the body occur if procedural rules do not dictate what the administrative hearing officer should do. In that case, the administrative officer or the administrative body presiding over the case must do the following: allow time for each side to present oral and written evidence that has not already been submitted, and determine when to take public comment and for how long. In addition to making those decisions, the hearing officer must make sure that the complainant meets its burden of proof. Burden of proof is the obligation of a party to introduce evidence sufficient to either prove or disprove the existence or non-existence of a fact or facts in dispute on an issue raised between the parties. What is hearsay? Hearsay is an out of hearing statement offered inside the administrative hearing for the truth of the matter asserted. Typically, hearsay is a witness or a document that provides evidence of a statement made by a person that is not present during the hearing. Now, in a civil case or a criminal case, hearsay is generally inadmissible, except as provided by law when there are exceptions and exclusions. However, in the administrative process, hearsay evidence, that evidence offered by a witness or a document that is not present before the hearing, is admissible when supplementing or explaining other evidence.
We will now talk about the hearing officer's role in preparing and finalizing your after-hearing recommendations to the full commission. This document is known as the Findings of Fact and Conclusions, and more about this can be found in subsection 7I of the Commission's complaint procedures on pages 13 and 14, which is hyperlinked to this PowerPoint at the end of the presentation. What are findings of fact and conclusions? Findings of fact set forth the facts that you as the hearing officer found to be true. The conclusions of law are the conclusions that you've reached regarding those facts. Making findings of fact will require you as the hearing officer to make credibility findings. Credibility findings will require you to support any conclusions with factual evidence. In weighing the facts, you may also take into account witnesses' demeanor, memory, and their consistency in testifying. It is the obligation of the parties to introduce evidence sufficient to either prove or disprove the existence of the facts in dispute on an issue raised between the parties. The standard of evidence we use is preponderance of the evidence, which means that it is more likely than not or over 50%. Factual evidence is used to sustain or support a party's position. Evidence is usually presented at the administrative hearing and is typically of two types. Documentary evidence consists of something concrete, such as documents, records, recordings, and other similar materials. Testimonial evidence is statements made under oath by individuals testifying at the hearing. The ex parte communication ban continues through the preparation of the findings of fact and conclusions. The timeline for preparation and submission of the findings of fact and conclusions can be found in subsection 7I of the Commission's complaint procedures. The findings of fact and conclusions must be returned to the Executive Director within 14 days of the hearing. The Executive Director then delivers copies of the findings of fact and conclusion to all parties. After this point, any party can request a rehearing in writing to the Chair within 7 days, with copies to all other parties. Other parties can respond in writing to the Chair within 7 days from receipt of the written request. The Chair then determines whether to rehear and the process for doing so. The Executive Director then places the findings of fact and conclusions on the agenda for approval at the next regular Commission meeting or special meeting called by the Chair.
We will now discuss how penalties are imposed. In addition to making factual findings and conclusions, the hearing officer may also issue a recommended penalty. The full commission will decide at one of its public meetings whether to accept or modify the recommended penalty. The commission cannot modify the hearing officer's factual findings underlying the penalty recommendation, just the penalty itself. In determining the appropriate penalty, both the hearing officer, when making their recommendation, and the full commission, when deciding to accept or modify the recommended penalty, must stay within the penalty range given by the actual ordinance they are enforcing. Depending on the type of violation, this penalty range can vary on the low end from $0 or even a warning letter to a fixed upper limit, usually $5,000 per count, or 3 times the amount of money that the respondent unlawfully gained by committing the violation, whichever is greater. In determining the appropriate penalty within that range, both the hearing officer, when making their recommendation, and the full commission, when deciding to accept or modify the recommended penalty, can look to a document called the Commission's Penalty Guidelines for general principles and factors to consider. It is important to note that these guidelines are advisory only and do not limit either the hearing officer or the full commission from using their own discretion and judgment to deviate from the guidance when unusual or particularly serious circumstances exist. As for the penalty guidelines themselves, they recommend weighing relevant mitigating and aggravating circumstances. These include, but are not limited to, the following factors: the seriousness of the violation, including but not limited to the extent of the public impact or harm that resulted, and the presence or absence of any intention to conceal, deceive, or mislead by the respondent, and whether the violation was deliberate, negligent, or inadvertent, and whether the violation was isolated or part of a pattern, and whether the respondent has a prior record of violations and/or demonstrated knowledge of the rule or requirement at issue, or whether the respondent was someone who should have educated themselves on the law, for example, a candidate or a treasurer in a campaign finance case. Next, there is the extent to which the respondent voluntarily and quickly took steps necessary to cure the violation, either independently on their own initiative or after contact from the Commission. For example, in the case of a lobbyist who failed to file their lobbying reports, if they quickly acted to file those missing reports, the Commission could take that into consideration as a mitigating factor. Next, there is the degree to which the respondent cooperated with the Commission's enforcement activity in a timely manner. This includes things like responding to investigators' requests for documents or an interview, as well as their truthfulness during an interview or the hearing itself. It also includes whether the respondent cooperated in the hearing process itself. It does not include a respondent's legitimate invocation of their legal rights. For example, if they challenged a subpoena on legitimate grounds, even if they ultimately lost the challenge. Next, the Commission can consider the relevant experience of the respondent. Now, while ignorance of the law is no excuse for liability, we generally hold people who are or should be familiar with ethic laws to a higher standard than those with less experience. This list of factors to consider is not an exhaustive list, but rather a sampling of factors that could be considered. There is no requirement or intention that each factor or any specific number of factors be present in an enforcement action when determining a penalty. As such, the ability or inability to prove or disprove any factor or group of factors in no way restricts the Commission's power to bring an enforcement action or enforce a penalty. It is important to remember that the hearing officer, when making a penalty recommendation, and the full commission, when making a final decision, both have very broad discretion when deciding upon a penalty. So long as the penalty is within the range prescribed by the applicable ordinance, the hearing officer and the commission may select a penalty that they believe is the appropriate one under the totality of the circumstances. It's similar to serving on a jury. While the judge gives instructions to the jury, ultimately each juror must decide for themselves on a verdict using their own judgment and intuition. Ultimately, the decision of what penalty to impose is an art and not an exact science.
We will now talk about the final order, which is approved by the Commission. The Commission must adopt the hearing officer's factual findings and may adopt the conclusions in whole or make modifications to them. These modifications can be anything within the Commission's jurisdiction to impose, from the penalty guidelines, from dismissal to imposing penalties. But the modifications must be supported by the hearing officer's findings of fact. The Commission must determine whether a violation of a city law over which the Commission has jurisdiction has occurred. The standard of proof here is if the evidence shows that it was more likely than not that a violation occurred, then the Commission shall find a violation. This preponderance of the evidence is of greater weight or more convincing than the evidence which is offered in opposition to it. Taken as a whole, the evidence shows that the fact or facts sought to be proved are more likely than not. A decision must be final before any court of appeal will accept and hear it. For purposes of finality, an administrative decision must be final with respect to action by the administrative agency and effectively conclude the issues. The Commission's decision is final once it has been approved by a quorum of the Commission and is made public. We will now discuss if and how the Commission's final order, which is based on the hearing officer's findings of fact and conclusions, is appealable. Only a court may review the Commission's administrative orders. Upon conclusion of the administrative process, any party contesting a decision of the Commission may file suit for injunctive relief, declaratory relief, or writ of mandate in any court of competent jurisdiction within 90 days as provided by law. Courts also use the substantial evidence test in reviewing administrative decisions. This means that if there is any credible evidence supporting the administrative order, the court will not change or overrule it. In addition, the Commission's own rehearing standards maintain that the factual findings should be free from one or more material error which affects a conclusion, and the conclusions should be supported by substantial evidence. Courts may take these rules under advisement when reviewing Commission orders.
We have come to the close of our presentation today. Thank you for reviewing the Public Ethics Commission's training on administrative hearings. If you would like to read more on the topics, see what resources are available, or just take a deeper look at the information you've learned here today, please take a look at the City Charter, the Commission Enabling Ordinance, the City of Oakland's Public Ethics Commission Operations Policies, Enforcement Complaint Procedures, Enforcement Penalty Guidelines, and the new Commissioner Handbook.